Please, Your Lordship. I beg to mention a review petition, Your Lordship, for listing, Your Lordship.
Listing, give it to the court master. All praise for listing, give it to the court master.
May I please, Your Lordship? Your Lordship, I beg for mention for item number 5.
Item 5, you want an adjournment?
Yes, Lordship.
Okay. Both sides are represented on the prayer made by Learned Counsel for the petitioner. Matter is adjourned today. List
2 weeks.
after 2 weeks.
Oblex.
My lord, item number 2027 may be updated. 2022, my lord, sorry. 22 WPC 6125.
WPC 61.
Yes,
Criminal.
WPC criminal.
Okay,
double
double two. Okay. What do you want?
Maybe upgraded.
Okay.
Lordship, I beg to mention item number 25, Your Lordship. May it be adjourned for the day, Your Lordship. 25,
25.
Lordship.
You
Jamila,
want an adjournment?
Lordship.
Okay. Both sides are represented. List after a week is paid for by Learned Counsel for the petitioner.
Wait, please, Lordship. Lordship, I beg to mention item number 26 for upgradation, Lordship.
Upgradation. Okay.
Yes, Lordship. Obliged.
Item 20, I need an accommodation for the day, maybe at John's.
20.
20.
Okay. Both sides are represented on the prayer made by Learned Counsel for the petitioner. List after a week.
May I beg, Your Lordship? Lordship, with the consent from other side, I beg to mention item 2, Lordship. The matter may be listed after 2 weeks.
Same order, 2 weeks.
May I please, Lordship, I beg to mention item number 14, Lordship. And a possible the matter for a day, Lordship.
1 4.
Putting just wait till we take up the matter. We'll accommodate your prayer, but let us take the matter because they are old pending cases. It has been specifically listed.
May I please, Your Lordship, I beg to mention item number. I beg to mention item number 10, and the matter may pass over for the day only.
This 2017 matter, please wait till the matter is called.
Single bench, item 1 for motion. Division bench, item 1 for motion.
This is also for the respondents. Pursuant to order passed earlier, the records of the tribunal is received. Next, in view of the which page is the opinion?
Opinion is at page 44, my lord.
34.
44.
42.
Is an ex parte order, my lord.
Ex parte opinion.
Yes.
Yes, what is your explanation for not appearing?
My lord, already I have stated, my lord, what had happened after receive the notice by the petitioner. He contacted with an advocate, my lord. And after peruse the records, my lord, he suggested that he need not to appear, my lord, because of the fact that in the inquiry report, my lord, it has clearly stated that the proceeding may be dropped, my lord. In that aspect, my lord, he did not appear. On the next day, my lord, the ex parte order has been passed.
It has to be allowed. There's no reference at all.
Lordship,
This has to be allowed. There's no reference.
Yes, my lord.
Look at the record. The SP's endorsement is not there to proceed. The report of the IO is that he's an Indian.
yeah,
That has been accepted by the DC.
but it does not attain finality, Lordship. Because law has already settled, Lordship, regarding that, Lordship. Inquiry officer's report does not attain finality,
Oh,
Lordship.
no, Supreme Police,
Yes, yes.
I give you flash. Thank you for you. Because if he's an Indian, he can't be referred. There can't be an opinion. Here we can say we both have made microscopic examination.
DCB border has communicated lordship. The reference, DCB border has
But where is the
communicated.
reference? There is suspect to be a foreigner. You will have to say that I disagree, I disagree with the opinion and then hold him to be a foreigner.
Yeah.
The opinion that he is a foreigner is not there. Star Islam, the counsel for the petitioner, and so for the respondents. Filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the impugned ex parte opinion dated page 44. Dated so and so, 19/6/18, passed by so and so in 50 case number so and so, corresponding to police case number so and so, thereby declaring the foreigner of post 1971 stream. Next one. Pursuant to the orders passed earlier, the records of the tribunal is received. Full stop. On the perusal of the records, it appears that the inquiry of that the inquiry officer, having examined the witnesses and his petitioner, on witnesses and on receipt of in reply received from the in charge of Kaya Kusi police station by report dated 6/2/2018 to the effect that the petitioner is an Indian by birth, recommended that the case be dropped. Full stop. Nonetheless, the matter was forwarded to the Foreigners Tribunal, Kamrup Metro, Guwahati for opinion. Full stop. In terms of the said recommendation made by the in charge, border branch, Patasil Ambari police station, dated 9/3/2018, the matter was taken up by the Deputy Commissioner of Police within bracket border, it was Guwahati, and without expressing any disagreement with the opinion of the inquiry officer, merely forwarded the matter to the Foreigners Tribunal, Kamrup Metro number 5th for opinion, without disclosing any material as to why he suspected the petitioner to be a foreigner of post 25/1971 stream. Next para, it is too well settled that without a reference made by the authorized officer suspecting a person to be a foreigner, the foreigners tribunal would not have jurisdiction to entertain proceedings against a person who is not suspected to be, who's not suspected to be a foreigner, but against whom but in respect of whom the opinion of the inquiry officer is that he is an Indian. Next para, resultantly, comma, the in the absence of any reference against the petitioner, comma, the impugned opinion is found to be vitiated, as the tribunal would not have jurisdiction to examine the claim of, examine the reference in respect of an Indian. Next para, resultantly, comma, the said impugned opinion dated 19/6/2018, passed by so and so, is hereby set aside in quest. Just before that, you say, that second paragraph, or not second paragraph, where we say that before this last paragraph, we say that the Standing Council for the Foreigners Tribunal has made its submissions in support of the impugned opinion, stating that once an opinion is rendered, that would override the observations made by the inquiry officer in respect of the petitioner. So accordingly, the petition stands allowed. The impugned opinion so and so is hereby quashed. Next paragraph, the next paragraph. The petitioner shall produce a certified copy of the order before the Deputy Commissioner of Police within bracket border, Kamrup Metro Guwahati, to bring the order to the notice of the said authority. Next paragraph, the registry shall send back the records of the tribunal back along with a copy of the order to be made a part of record by the said learned tribunal. You seem to be dissatisfied.
Yes. Well,
You are very serious. You seem to be dissatisfied with the order.
no, I don't
No.
much of
Lordship, Lordship, the chief order is at liberty to make a reference, Lordship, initiate a
No, no,
reference
it can't.
on the basis of
It can't.
the inquiry, because there is an inquiry, Lordship.
It can't.
Huh?
The inquiry report is not there. That is the problem. The man was not available in Guwahati. So therefore, the IO, we will have to appreciate whatever he did was, he wrote to the Kayakusi OC to make an inquiry and send the report. And that report was sent. And the SP is the superior officer, the Deputy Commissioner of Police is a superior officer. He has seen, observed that what has happened. And thereafter just referred it. We don't suspect him to be a friend, therefore we can't do it.
Oblige.
Item 3. Item 4 for motion.
Map resolution. But here in this case, I was asked to get instructions. I have issued the instruction. And the petitioner also appeared before the concerned Malad holding center along with one of his family members, and he met his mother Malad. And accordingly, one wakalatnama has been signed, which is attested by the police also from Kokrajhar Malad. That has been sent to me. Lord, there is a, I need to, my lord, submit 2-3 lines before your lordship, my lord. Since the, my, Let it be on next. Let it be on November, October 20, 27th, Monday. Yes, Millard. Millard, this lady was earlier Millard declared to be a foreigner by virtue of an expert. Your lordship is well aware of that. And that has been put to challenge, Millard. And unfortunately, in that particular case, I am not the engaged counsel, Millard. Therefore, since the Wakalatnama has been signed by the Millard detenue, now your lordship will kindly advise me, Millard, whether I may be allowed to file, Millard.
Another
My lord, I'll wait till then.
8 years this side. You want this side, then
No,
we
my
can
lord.
advise you.
Lordship, because, my lord, this brief was not handed over to me. If I need to get the, my lord, NOC to file an IM, my lord, or to file a fresh my lord writ petition, that would be my lord.
We both are otherwise, what you call, great fans of arm wrestling championships. If otherwise NOC fails, you can try that. But invite us. We in fact, since it is at a challenge,
Yes,
it is for technical purpose. We want to keep it alive for some time.
yes,
We have to see the ultimately the documents which are there. We'll have to be satisfied ourselves. We adjourn the matter. We don't say anything.
my lord.
We just record your statement that in the meantime the opinion has been challenged. Huh? We just stop there. We don't say anything more.
And regarding the bail part of the my lord. Okay, no, connected. It could be.
Also, it's a represented. Mr. M.R. Adhikari, Leonard, CGC has produced a set of documents along with the instructions received from the concerned officials of the officials on behalf of the Inspector General of Frontier Headquarters, BSF. Along with the court query, the learned CGC takes for some time to respond to the same. Next panel, the learned counsel for the petitioner has submitted that as per instructions received by him, the petitioner has, during the meantime, has challenged the impugned opinion dated 29/10/2015, passed in the concerned FT case. First of all, we take note of the said submissions. Next, this is the matter on 27/10/2025.
Item 44 and 45, yesterday's matters, there also the documents are same.
Same,
Yes, my lord.
44 and 45.
Yes,
My lordship, in this case, I have filed one IA for fresh bail, my lordship. It is remain pending for consideration, my lordship. Kindly see the order dated in the IA application 3228/2025.
We just adjourned the matter for fresh consideration of the bail application. That's what we passed.
Yes, my lordship. In this case, one of my sister has been declared as Indian, my lordship. And also, my lordship, I was regularly giving attendance to the local police station.
What is the date when you were taken into custody?
24th May 2025. I have stated in my writ petition, my lordship. In WPC 34/2025, I have stated it, my lordship. Till 21 May 2025, I appeared before the local police station as per the Supreme Court order. But the problem was that during that time, the engaged counsel failed to give the copy of the High Court order. But both the orders were same, my lordship, as per Supreme Court order.
Not today, Lordship.
My lordship, it has been
Not today, Lordship. Lordship, here he was already in holding center at 7th Epibian Saraikula, Lordship. So, Lordship, and earlier he was released on conditional bail, Lordship. After that, one High Court order has been passed that was not placed before the concerned authority. And That is why Lordship, he was, Lordship already arrested, apprehended, and Lordship, they kept on detention camp. And he was already handed over to BSF, and also I think after handing over, he returned back, and yes,
Same,
yes,
same, madam.
same.
If, my lordship, I have been handed over to be,
Yes, madam. Same instruction.
Yes.
my lordship, I have bring one judgment, my lordship, if lordship may permits me. Suppose I have violated
The state's contention is that you have been handed over to the to the Bangladesh authorities, and from there you came back again.
Yes.
If that be so, then your prayer for bail would be rejected. But we wanted to satisfy ourselves with the handing over and taking over, and that is why we are adjourning the matter. We can understand what will come from you. But we don't want to, since you see, you have stayed there for more than 5-6 months.
yes, ma'am.
We intended to release you, but the documents in the bunch of papers which are produced, there's some document is missing. We want to satisfy ourselves with that.
Can it be fixed on 23 of this month?
27th we are making, because they will have to get it from the authorities and get back.
27, 28, 29.
You are not
I'm
there.
out of Station. Can it be 26, 25?
Okay,
Mhm.
he'll be out of station on 27th.
27, 28, 29, 3 days. So 26, 25th, any day, any day.
29 in both the cases, madam. Then
26, 26, 27, 28, 29, 3 days.
29th will not be there.
30, madam. 30 is first day, madam.
Okay. Because of Diwali, they are 2-3 days in the army also, they will be
Yes.
having difficulty in getting documents and sending it.
30th, madam. Both the
Then
cases.
27,
No, that remain on 27. His case, we take it up on.
27, 27, my lordship. Okay, my lordship.
No, if you are out of station, don't.
I will manage it, my lordship. Then 28, 29, I cannot manage, but 27, I think I will manage it somehow. It is my, he's
You
been.
can ask some of your colleague to remain there.
Yes.
And just remind us that the person was taken into custody on 24/5.
2025.
Just ask some of your colleague to be here. Tell us, we'll remember it. Mr. Adhikari, just remind me of.
There are, madam, in between there is Diwali, madam. Can it be on 38th?
No, 30 we are fixing it, but he has some difficulty. So 27th we are taking it up. He is having some difficulties on 27th.
Yeah.
So if his colleague, any colleague of his stands up, please remind me of
Madam.
today, and then we'll.
Fine.
We'll see that. If any adverse orders are passed, we'll adjourn it. Otherwise, we'll take it up.
Fine.
Ask some of your colleague to be here. He may not be, may not the matter, may not know the matter, but let somebody represent you. Don't be in default.
Okay.
Correct. Just remind us of today. Perhaps we'll recollect. Same order. Last order, same. It is 27th. Just writing the order, the counsel for the petitioner submits that on that day he may be out of station. Most of in that event, he may request any of any other counsel to represent him on the said date. Just let anybody be here.
Madam, on this point, madam, I had asked for some instructions, madam. They gave me some other instructions, madam. It will not be good for me to disclose it.
No, that's why the problem.
Yes, ma'am.
You are understanding.
Yes, ma'am. I'll get it in writing. Yeah. All right.
Because you see, Mr. Adhikari,
No, no.
5 or 6 months, if somebody is in the detention center, then perhaps they'll be entitled to bail.
Minor.
Because so they also submits that the otherwise the compliance of the appearance order was there.
And one of my sister, my lordship, already has been declared as Indian. And in the document and in the Honorable High Court, there is one order I have already submitted earlier only, that if one brother or sister has been declared, there cannot be any doubt that other brother or sister is not Indian. That is there, my lordship. I have already
We'll examine that.
Yes.
yes,
Alright,
it is there.
We'll examine that.
Yes. And deeply obliged.
You see, Mr. Day,
Sorry, my
uh, in fact, you will also understand that in course of our deliberations in this bench for some time, we come across many judgments which are placed before us. One of the judgments we can readily cite is that in the event such discrepancy happens and the opinion of one is not placed in the tribunal for the other, then both the orders may be interfered with and then
Yes.
be sent for common adjudication. So in fact, the person who has been declared to be an Indian, or even his, by default, his opinion is set aside and taken up for common adjudication.
actually, my lordship,
No, whatever is there, we are just telling you that we are not oblivious of what is happening, but since it is only for bail for the movement, we are just accounting it.
okay, my lordship. Deeply obliged.
Item 6.
May I please, your lordship? My lord, the opinion at page 67, my lord. My lord, she was taken to custody on 25/5/2025. Yes, 67 is the opinion.
Petitioner, namely so and so, is apprehended.
No, he is already apprehended, Lord.
Huh?
He is already in detention, Lord.
Already apprehended. When?
Detention. 2007, alright, now.
Okay, then just say that the
25,000.
the learned counsel for the petitioner submitted that in the meantime, the petitioner, namely so and so, has already been apprehended on
25/5, my lord.
25/5/2025. So accordingly, it is provided that in the meantime, if the petitioner, namely so and so, has not been deported out of the country, she shall not be deported out of the country without order of the court. Next paragraph, the petitioner shall produce a certified copy of the order before the Superintendent of Police border,
Golaghat.
Golaghat, to bring the order to the notice of the said authority. Okay.
Oblige.
Item 7.
When 9, my lord, are identical matters, so it should be taken up with 39, 40, 41 of the supplementary list.
Item number
9 of daily list, 39, 40, 41 of the supplementary list.
okay. Yes,
My lord, in the item 7, my lord, the impugned order, page number 18, my lord.
18.
18, my lord. This
And
is
what
of
are those other matters?
other, my lord, item number 9 is of the brother. Same, on the same day, my lord, they were arrested on the same day. They approached your, this honorable court. But, my lord, of item 7, page 46, my lord, is the order of the earlier, case that they filed.
Page,
Page, relevant portion, page 47, my lord. Item 7, page 47, my lord. May I read, my lord? On the last parameter, please.
no locus standi challenge.
My lord. Yeah. No locus standi, yes, my lord. A wrong plea was taken. Subsequently, it was dismissed and then they were in detention. My lord, both the brothers were released, my lord, on 22/4/2020. And then again rearrested on 25th of May 2025. Now they are in Kokrajhar Holding Center. Subsequently, my lord, against the pushback, we filed a petition that is pending before your lordship. And then because we had no wakalat namas, the nephew challenged this impugned order of the learned tribunal. And because he also cannot challenge your lordship on the last day, my lord, was pleased to grant us permission to get wakalat namaz. We got the wakalat namaz, and these two petitions, 7 and 9, is before your lordship. My lord, I would, in that case, I would like to withdraw petition number 39 and 41. Let 40 be there. 39 and 40 were challenged, the impugned order was challenged. Now that the petitioner is challenging, so 39 and 40 I will withdraw. 40 was against the pushback. There, the state has filed a reply. We have also filed a reply, my lord. Let that be that, tagged with these two matters. 39 and 41. 41. Let 40 be there, my lord. But maybe tagged with these two matters.
Next one, upon instructions, upon instructions and with the statement that the separate writ petition has been filed for challenging the tribunal's opinion, he seeks to withdraw this writ petition. Next one, prayer is allowed, matters dismissed on withdrawal without prejudice to the challenge, the challenge made in the connected writ petition, in the fresh writ petition already filed. These two gone.
My lord, grateful, my lord. My lord. $47 million. Last para, my lord. First para. Heard Mr. Learned counsel, the petitioner as well as G. Sharma. My lord. Maybe listed the very next day after, on Wednesday, my lord. Not Wednesday, my lord, I'll be on leave from Thursday and Friday. Humble request, my lord, on Wednesday. My lord. My lord. My lord. My lord. Grateful, my lord.
Item 8.
My pleasure, Lordship. Well, it is against ex parte order. Notice, of course, will receive. My lord, notice is at page 46. Opinion. That is page 52 and exact 20. Okay, we'll issue notice. 23 opinion. Mr. N. Islam, Hawk Learned Counsel for the petitioner. And so for the respondents. Page 52. Ex parte opinion dated 17/5/2023, passed by so and so and so and so. Thereby declaring the petitioner to be a foreigner of post 25 in 1971 stream. Notice returnable on so and so. Extra copies within 2 days. Call for the relevant record from the concerned tribunal by sending requisition to the following email address. Next paragraph. Prayer for bail shall be considered on receipt of records. Next, in the meanwhile, if the petitioner, namely so and so, is apprehended, he shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of the certified copy of the order before the Superintendent of Police border. Which place? Borpeta, to bring the order to the notice of the said authority. List on so and so.
Supplementary item 37 for motion.
My pleasure, Lordship.
Notice has already been issued.
Lordship. As per last order 39/2025, Lordship, some record was pulled.
Yes, you'll have to address us on the issue of maintainability.
Sure.
You're challenging the 2019 opinion now.
Lordship.
What is your explanation for the delay?
The delay part we have mentioned in para 20.
Just
Okay. Oh, yes, let's continue. Yes, yes. Test 28, huh? Test 28. 28. 28. Just a last order 39 minutes. Yes, yes. You mentioned. Yes, yes. Okay. Lottery में पीसी तो हम next Friday lottery on Monday lottery. Lottery, lottery we can be 27 lottery, 27. That's it. Yeah, that's it.
Item 38.
They have to come out with কিহৰ কাৰণে shoot কৰে? Order to public.
Item 38 for motion.
With your lordship. I'm sorry, your lordship. Oh, no, sorry, your lordship. Your lordship has asked me to produce a postal track report, your lordship, postal track report, your lordship. Lordship, I got a postal track report, but it's a little confusing, your lordship. Yes, your lordship, definitely. Yes, your lordship. Yes, your lordship, I have checked the post, originally it was with me, your lordship, but. So, lordship wants to peruse the original, I have got it, your lord.
Yes, yes, Lord. Yes. Hmm. In that, Annexure 19. Annexure 19. Fine.
Lordship, can we, may I come back at? Originally. Lord. Okay. Okay. Lord. Lord. Lord.
Supply item 42.
Page Lordship. The case was that the improperly order has been passed at case number 22. It is fiscal
Lord-
instruction, Your Lordship.
Lordship, in 58 Nagaon Lordship, there was no case in respect of the petitioner, but from 52nd Nagaon, that instruction has not yet received Lordship. I think okay. And There is no pending case against the petitioner at FT8 Nagaon Lord. Lordship, from FT second Nagaon, I don't FT2, I don't get the instruction from FT2 Lordship, but from FT8, I get the instruction there is no pending case against the petitioner Lordship. But notice was issued.
I think you could have, you can please take the information from the SP border.
Yes, Lordship. So them I am collecting Lordship.
Oh, from through them only.
Yes.
So SP border also does not have record of such case.
Yes, Lordship, from FT second Lordship.
No.
They
Reference-
forwarded the
No. Reference originates from the office of the Superintendent of
Yes,
Police
Lordship.
border.
They have sent it to FT second Lordship.
Acha, it originated. It
Yes,
was sent to,
yes, Lord.
to.
No. But their contention is that FT second has intended. Lordship, otherwise Lordship may get F2 Lordship.
Perhaps the bench is not there.
Huh?
No, sir.
Definitely. Then Lordship, for the time being, I make a telephonic call to the
नहीं उसके बाद में जब मेरे को बोलते कि ट्रांसफर स्टेटमेंट दे रहा है
Sharma, you inquire from the second finance tribunal number 2, Nonga. Pending, it's not pending, but where did they send the records?
yes.
They'll have to say,
Yes, Lord.
and these records are not sent through the SP office.
No.
The courts themselves
Yes.
transfer
Lord.
the records
Yes,
by
sir.
peon or something.
Yes.
Find that out, come back before 1 p.m. here.
Yes, Lord.
Certified copy,
Yes.
my
I
lord
get
has
the
gone,
notice, sir.
it's in 19.
Yes.
Certified copy was given. Where is the records?
Yes.
You make a call.
Yes.
Supply 43.
May I please know? Expert order, annexure 1, page number 19. Petitioner is arrested on 25/5 and he is under 7th APPN holding center.
Mr. Sharma,
Yes, doctor.
I think this case will have to interfere in the motion stage only.
Okay. Okay.
Look at page 19
Yes, doctor.
in the last about 7, 8, 10 lines. But the notice was sent to his permanent address, return answer with a report process over that village number 3 has 3 parts. And since the specific part is not mentioned in the notice, therefore the process server could not serve the notice. Therefore, the notice was deemed to be duly served in the present address as per 35G. And
Oh.
before that, there's it was hanged in the office of the Gaon Panchayat, para 2, about 6 lines from the top. Notice is served by hanging in the wall of the Gaon Panchayat office.
Yes, doctor.
And the process server said that there are villages in 3 parts.
Hmm.
How is the notice served under 35G? And the petitioner has been taken into custody, I think. Yeah, you are in custody.
Yes, my lord.
Medical option. Doctor.
Thank you. Thank you.
S.U. Ahmed.
Heard Mr. A.K. Atta.
S.U. Ahmed.
S.U. Ahmed, learned counsel for the petitioner, also heard the correspondence with the liquidity person respondents. So the present writ petition has been instituted SLE. The order dated 18/3/2025 passed by the Pointers Tribunal Jorhat in FTG in case number FTG 999/2011, page 19, declaring the petitioner herein to be a foreigner, post 25/3/1971 street. Full stop. The learned counsel for the petitioner at the outset has submitted that the said opinion was rendered by the learned Foreigners Tribunal by holding that the notice issued by it was duly served upon the petitioner under the provisions of section 3(5) bracketed 5 bracketed G of the Foreigners Tribunal, Foreigners bracketed Tribunals bracketed over order 1964. So he submits that the petitioner had not received any notice in the matter from the Foreigners Tribunal preventing him from appearing before it. Also, the learned counsel for the petitioner has further submitted that in pursuance to the ex parte order opinion dated 18/3/2025, the petitioner was placed under detention on 25/5/2025 and continues to be under detention as on date. Mr. G. Sharma, learned counsel, appearing for the learned standing counsel, FT, appearing for the state respondents, has submitted that opinion having been rendered by the learned tribunal, the same has to be maintained inasmuch as the petitioner has not even in the present proceedings demonstrated that he was an Indian citizen and the reference as made against him was erroneous. We have heard the learned counsel for the parties and also perused the materials available on record. On a perusal of the opinion dated 18/3/2025, it is revealed that the notices issued upon the petitioner by the Pointers Tribunal was not served, inasmuch as the petitioner was found to have left his place of residence for unknown destination. So it is seen that the notice was thereafter served by the process was pasted by the process server, by the process server, on the wall of the Gaon Panchayat office in presence of the Gaon Pradhan. So the provisions of section 3 of section 3 further it is also seen that the notice issued to the petitioner at his permanent address was also returned unserved with a report of the process server that village Boilakmari Gaon has 3 parts, and since the specific part was not mentioned in the notice, the process server was not in a position to serve the notice in question. Also, the provisions of section, provisions of order 3 bracketed 5 bracketed G mandates that when the proceedee or any adult member of his family or her family is not found at the residence, a copy of the notice shall be pasted in a conspicuous place of his or her residence, witnessed by one respectful respectable person of the locality, subject to his or availability and willingness to be a witness in that regard, and the process server shall obtain the signature or thumb impression of that person in the manner in which such notice is, such service is effected. Full stop. Subpara. Having having noticed the provisions of Sec Order 3 bracketed 5 bracketed G, this court, we find that the notice was not served upon, cannot be mandated to have, cannot be deemed to have been served upon the petitioner herein, inasmuch as the said copy of the said notice was not pasted on the posted at a conspicuous place of the residence of the known of the residence of the petitioner known to the authorities. In view of the above, we are of the considered view that the ex parte order dated 18/3/2025 would not be maintainable, and accordingly, the same stands set aside. Having interfered with the order dated 18/3/2025, we require the petitioner herein to appear before the learned, before the Foreigners Tribunal Jorhat in FTG 999/2011 on 3/11/2025, along with a copy of this order. The tribunal shall thereafter proceed with the reference strictly in accordance with law and complete and render its opinion in the matter expeditious. With the above observations and directions, the present. In view of the fact that the petitioner here, the opinion dated Uptaraguna, dated 18/3/2025 has been interfered with, the petitioner would now be released from detention by the detaining authority. Such detention be made, the petitioner be set at liberty by the detaining authority immediately on being furnished with a copy of the present order. Petitioner to serve a copy of the present order upon the Superintendent of Police, Border, Jorhat, for the needful in the matter. Gulagat, for the needful in the Gulagat.
Yes.
For the needful in the matter. Also, with the above observations and directions, the present writ petition stands allowed.
Obligement.
Upgraded item. Upgraded item 22.
May I please your lordship. Alright, this is PIT NDPS matter. And the detaining was under detention by order dated 5/6/25 and issued by respondent number 2. That is on detention order is at page number 15. Page number 15. But in this case, all total 11 grounds were not.
Quantum Police Vishwanath file affidavit. SP Vishwanath file affidavit.
But as on date 129, 9 days behind the detention without confirmation order from the advisory board. And my lord, we served detention representation on 37/2025. My lord will come to
No, sir. Lordships. Lordships, I have received one email matter for Home Government and representation matter submitted 13/7/25 to the Secretary Government of Home Department and Superintendent Police now and received on 13/8/25 and is under consideration of the appellant authority. It was just before Puja vacation. Last instruction I have not read. Because I have taken mail just before Puja vacation. I was out of station now. Hyderabad was that time. I cannot not file. Letter was not listed for the time. Pair of file. Under consideration. Thank you. I have some problem with 25. 27. 23rd is after the BT, I will have 23rd. Festival is 27.
but on 15/9, there was it was honorable court ordered them to file affidavit.
I find
And
I-
only the
already filed.
only the Biswanath Superintendent of Police's file, and no affidavit is filed from the detention authority, that is respondent number 2. My lord, as on date, without confirmation order is beyond 90 days, 129 days.
I'll file affidavit then.
Passed by the advisory board.
No.
My lord, is in NDPS proof, it is available. It is in section 9.
90 days. No?
Mm.
It is. Yeah. Sorry, yeah. It will be as an. 90,000. Somebody does. Within the 11 weeks from the calculation of completion. Huh? Not like it. Eleven. 11. 11.
Alert section 9 surplus C, last part.
Days of. Second.
129 days.
Okay. Then you will also fix on 22. 22 you will also 22. Okay. No, 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 they are in office or normal telephone number for is in office. In our government office. So 22 I will bring all the stuff. Yeah. Wait.
Yes, item 26.
My lord. I have filed an IA in this lordship for her release lordship. She is there from in the detention since 2012.
2012, 24.
Yes, lordship. I have filed an IA.
But you are selling the opinion of 2018 now.
Yes, lordship. And we have stated the reason, lordship.
What is the reason?
Yes, lordship. It starts from paragraph 55, page 49. That though the petitioner was aggrieved by the order, public opinion dated so and so, passed by the learned tribunal number 6 Barpeta in FT case number so and so, but due to extreme financial scarcity of the petitioner could not approach this honorable court within a reasonable time. The poverty is the main curse of the life of the petitioner. The petitioner is a housewife and do not have any source of income. She is fully dependent on her husband's meager income. The petitioner does not have financial independence. The petitioner belongs to the marginalized section of the society and she
Independence, don't say about that independence.
lordship, she is a housewife, lordship. And she is fully dependent upon the meager income of her husband. And for that reason, lordship, and even earlier, legal aid was not provided to this sort of cases. In one of the case where I have appeared on behalf of that petitioner, that petitioner was behind the bar from 2010 February, 10th of February, because on that day itself he was arrested, and till the end of 2018, no writ petition was filed because of a financial constraint of that person. So earlier, legal aid was not provided. Now, these days, legal aid is being provided, lordship, and we are providing pro bono service to this litigant, lordship. My humble prayer is, yes, definitely, it's delay. Quite some time delay is there, but delay and latches was not in a hand, lordship. And if one chance is given, and even I admit that her WS is not properly drafted, but we tried to bring on all the additional documents before this honorable court. And one of our humble prayer is to remand back the matter also, lordship. Otherwise, she has a good documents. Although those were not properly being placed before the learned tribunal. So at this stage, I'll pray lordship humbly before this honorable court, at least if she is released and thereafter may be fixed for hearing, lordship. And because in the length of her detention, lordship.
Yeah.
2012, 2024. His father has reduced evidence, Lordship. And she has exhibited 3 documents, but only proved 1, Lordship, which is at page 101, Lordship. The Gambura certificate. I can link with my parents, is the Gambura certificate, Lordship. But that document is not proved. The document which is proved is of the village is at page 101, wherein her husband's name is written, Lordship. But her father has adduced evidence, and the document, the voters, the Gambura certificate and the Panchayat certificate of her father's village is not duly proved, Lordship. And although while going through the records, Lordship, notice was being issued to the Gambura of that village, but the Gambura did not come, Lordship, as per order dated, which I understood after going through the records, Lordship. After going through the records. Okay, Chairman. About steps. But the Gambura did not turn up. As per order dated 22/11/2016, page 5 of the record, Lordship, which has Abdul Aziz Abdul Hussain. He was issued summon, but he did not come, Lordship. And now I have attached along with this writ petition one additional document which can link with my father, is the Kabilnama Lordship. Page 128 and 1. Kabirnama, which was not exhibited before, which he has annexed along with the writ petition, Lordship. It's Page 28 is the vernacular copy. 128, Lordship, 128 and 129, because it's a long document, we had to make into copies, Lordship, which this was not exhibited before the learned tribunal, Lordship. And the complete voters list, these were also not being exhibited, which as an additional document, I have our father's name along with grandparents are there from 85, Lordship. Because 66 is granduncle and grandaunt, 70 granduncle, grandaunt, grandfather, grandmother, and uncle. 85, 89, all together. Yes, Lordship. He was born in the year as stated. The petition was from the father. He is 45 now, Lordship. 1980. 80. Yes. For hearing, Lordship, I'll do the, at least my prayer is 22. And on merits also Lordship will hear. Yes. Lordship. Okay. Then I also need some more time to go through the records. I have spent time today to go through the records. I need more time also to go through the records. Yes, Lordship. On my side. Next Wednesday. Yes, Lordship. Deeply obliged. Lordship.
Yes, Lordship.
Other matters, we may not have time to take it up. All we were adjourned. The PIT NDPS matter would be taken up.
No, regarding item number 42, Lordship, I have telephonically taken instruction from them, but they are seeking some more time, Lordship, to find out the file, because file cases are kept in, these are file cases, Lordship, they are kept in different manner.
Okay,
Lordship.
when do you want?
Lordship, 1 week time may be allowed, Lordship.
We'll take it up on 27th then.
Yes, yes, Lordship.
Okay, both sides are represented on the pair made by Mr. G. Sharma, the net standing counsel for the FT and border matters. All the cases adjourned today, list on 27/10/25.
27.
27. And because Sharma, if this if that petitioner can be, that case can be tracked out,
Yes, Lord.
we can always direct them to go there and appear. Tribunal can take up the case.
Yes, yes, Lord.
That's why.
I received one mail, madam. Exercise of power conferred under section of the prevention of the traffic.
Just tell us what is the gist. You may not read it. Just tell us what is this then.
Confirm the
This is a letter of which date?
detention order.
What is the date of the order?
Asked by the that is order, my lord. 4th August,
Huh?
4/8/25.
Or 8/25. This is the confirmation order.
Yes, ma'am.
Then we are getting it listed on 23rd.
22, ma'am.
23rd, 22, not 22, 20. You will not be there.
23, I will.
Hmm?
23, I have.
23, you have some problem. 22. Okay.
22 or 24.
Then we'll make it 24.
My lord, apart from this ground, my lord,
We don't have time to hear today.
right. I did some homework and I prepared all total 11 grounds. All are strong grounds, my lord.
You can complete it in within 1 minute. You do it.
No, not possible. my
Go
lord.
on. 24 lots.
I place it for your lordship.
No, we don't stop hearing. Even for 1 minute, if you can do it in a capsule form, we are ready to take it up. But still to hear Mr. Sharma, we'll have to adjourn it. What's all sides are represented? Due to paucity of time, matter could not be taken up today. List on 24/10/25.
Or like.
Yes. 24 August.
We are not saying anything in the order, but you know what to do.
Yes, yes.
We file an affidavit or whatever. You're not saying anything in the order.
Yes.
My lord, may I take back those judgments?
That
Obliged.
Lordship, in item number 27, interim may be continued.
Did we give a, what the other, 27?
27, your lordship.
You see what is 27?
It's a foreign tribunal case, your lordship. Interim was given. The only prayer is it may be continued till the next order, your lordship.
This don't need an extension of the order. The order is not to deport you without order of the court.
Yes, yes, your lordship. Obliged,
Let
your
me
lordship.
continue.